Mr. Chairman, thank you. Mr. Grippo and Mr. Berner, thank you for testifying from the Department of Treasury, and thank you for your patience. Some of these questions that I'm going to ask may have already been asked. I had to miss some of this to go do an interview. But first of all, Mr. Berner, in your experience as Chief Financial Officer of this federal financing bank, which actually made the loan, provided the funds, have you been involved in restructuring of loan guarantees before, either in or out of government?
Only peripherally.
Let me ask you then this, maybe it's a bit hypothetical, but in cases where the terms of a loan guarantee were changed or restructured by other agencies, have those agencies sought the approval of the Department of Justice, to your knowledge?
If they don't have their own authority, then they would seek approval of Department of Justice. If they have their own authority, they would not.
Then let me ask Mr. Grippo, because what you just said, I think, is the crux of this matter. Is that the reason, Mr. Grippo, in your opinion, that the Department of Treasury said to the Department of Energy, look, there's a tab here, there's a red flag, and it is our strong advice that you consult the Department of Justice before going ahead with this restructuring?
We did not know what all of the Department of Energy's authorities were. We did not even know the details of the restructuring. We had heard that there would be a restructuring, and it seemed like good advice in our consultative role to tell them to seek to go to the Department of Justice, which is customary.
And I commend you for that. I think you're absolutely correct in doing that. Either one of you, why do you think that the DOE then was so hesitant to seek DOJ approval to get, a little bit more security, cover their back, why do you think they didn't do that?
I don't have an answer for you.
Mr. Bruno, any opinion on that?
I'm sure they had their reasons. I'm not really sure they had a legal theory on this, I'm sure.
Yeah. Well, if DOE, the Department of Energy, was so confident in their legal analysis that the subordination was permitted, why not go to the DOJ, to the Department of Justice, just to cover your base, just to get a little backup, CYA rather than CYB? Other agencies typically seek the Department of Justice approval of loan guarantee and restructuring. And I asked you that question. You said you're not really sure of that. Is that your answer, that you don't know? Mr. Grippo, I didn't ask you that specifically. Other agencies, do they typically seek the Department of Justice approval of loan guarantee restructurings?
Well, I don't have specific knowledge about other loan guarantees, but I'm generally familiar with what the statute says. And unless an agency has its own authorities, the procedure is to talk to the Department of Justice. And that's what we were doing. We were making a procedural call and saying, we can't make a judgment on what's going on here. We're not making a legal opinion, drawing a legal conclusion.
Well, I'm not putting words in your mouth. I don't want to do that. But it sounds like to me that you were strongly suggesting to them, since they did not have the statutory authority. I mean, I'll refer back to the Energy Policy Act of 2005 under Title 17, Incentives for Innovative Technologies, Section 1702, Terms and Conditions, Paragraph D, Subparagraph 3, Subordination. And you've heard this several times from members on our side of the aisle. The obligation, that is the loan, shall be subject to the condition that the obligation, the loan, is not subordinate to other financing. So that was your concern, was it not?
We were not interpreting that statute. We were recognizing it and offered the advice that...
Well, it doesn't require, I think my first grade grandson could pretty much read and interpret that. It doesn't take a rocket scientist. That's as plain as the nose on your face. And they literally ignored the warnings and went ahead with this. And the result, of course, is the taxpayer is in a subordinate position to $75 million worth of additional investment And when Mr. Silva was here and we asked him these questions, and we have it on video and audio, I mean, it's clear what he said to us. Look, we were thinking in our mind that the taxpayer would come out better if we found a way to circumvent and break the law. And that's what it's all about. Mr. Chairman, I'll yield back.
Thank you, Mr. Gingrey. At this time, we recognize the gentleman from Louisiana, Mr.